In terms of our agenda for today, um, do welcome introductions. We have our featured presenter presenting on qualified immunity, uh, Laura Kelly. Afterwards, we'll have a discussion and questions from everybody, and then we'll finish up talking about plan for organizing meeting and wrap up with what's coming up next in the next month or so. So, um, my pleasure to introduce our speaker, Laura Kelly, using she, her pronouns. She is an activism coordinator at the National Institute for Justice. She works with community members and decision makers to advance policies that hold government accountable for constitutional rights, against constitutional rights violations. She serves on the leadership team of the Illinois Accountability Coalition. She builds diverse grassroots supports across state to end qualified immunity, a legal doctrine that shields public officials, including police officers and SODC employees, from accountability when they violate our civil rights. With that, pleasure to turn it over to Laura. Take it away.
Thank you so much for the introduction, Jay-Jin. I'm going to go ahead and share my screen now, see if I have the official power vested in me to do so. Okay, looks like I do. There. All right. Is everyone able to see that screen?
Yep.
Yes.
Thank you. Well, like Jay-Jin introduced me, my name is Laura Kelly. I'm an activism coordinator at the Institute for Justice, which is a nonprofit civil liberties law firm and advocacy organization. I work on the Americans Against Qualified Immunity Initiative, where we work with individuals across the country at the state level to advocate for the end of qualified immunity. So I'm really grateful for the opportunity today to speak with all of you and to guest at your coalition meeting about qualified immunity and the work that the Illinois Accountability Coalition is doing to end qualified immunity statewide. I really admire the work that your coalition has done already statewide to advocate for justice and for your community and create meaningful systems change across Illinois. And I think and I hope that you'll find that ending qualified immunity is also about justice, accountability, and empowering your community. So today, like I said, I'm going to go over a little bit about what qualified immunity is, why it matters, how it specifically impacts the IDD community, and how any of you who may be interested can get involved in the reform effort in the state. I encourage all of you to stay engaged. You can drop questions in the chat. I won't answer them until the end, like we agreed in the housekeeping and just for the sake of time. But if you're worried you're going to lose track of your question, that's okay with me. And we can also engage at the end on those questions. So for today's presentation, I just did the who I am. We're going to hop into what qualified immunity is, and then we'll go over the history of it, some case examples so we can see how it actually plays out. We'll do a little bit of a reflection and debrief, and then I'll talk about how you can take action to support reform in the state of Illinois. So to begin, a plain language definition of qualified immunity is it's a legal rule that protects public officials from being sued for violating your constitutional rights, unless they violated a clearly established right. I'll go into later the specifics of what a clearly established right is. But the bottom line is that qualified immunity protects government officials, even those who are acting in bad faith, from being held personally liable when they violate your rights, unless the Supreme Court or the circuit court that Illinois is in our case, has a decision made prior that has found identical conduct under identical circumstances unconstitutional. So that's what that clearly established law is, and it's a really high bar for justice, because in order to show that their right was clearly established, a victim has to identify that earlier decision with the exact conduct under the exact circumstances. And if that decision doesn't exist, then qualified immunity will shield the public official from accountability. So an example of how that looks, a federal appeals court in Louisiana held that a prison guard who pepper sprayed an inmate for no reason did not violate clearly established law, even though there was a similar case in that circuit that said tasing an arrestee for no reason and hitting a person for no reason were constitutional violations. But because spraying with pepper spray is different than tasing or hitting, those cases weren't sufficient enough to make it clearly established that you can't use that excessive force, and the prison guard was shielded by qualified immunity. So as we see in that example, and as we'll see in more examples that I'll get into a little bit later in this presentation, qualified immunity doesn't just shield police officers, which is typically what people think of when they think about qualified immunity. Police officers do enjoy the shield of qualified immunity, but it's also used by prison guards, mayors, governors, school administrators, social workers, state-operated developmental center employees, all public officials, and some private individuals who are working with government workers, like private prisons or ankle monitoring companies, can also enjoy it. But the key thing to know here is that it's for public officials. This is a protection that is not granted to me or you as everyday American citizens and residents of this country. This is specifically for public officials. It is a special layer of protection that they enjoy. So just to talk about how qualified immunity came about in the first place. So the Civil Rights Act of 1871 is what really starts the process for qualified immunity. So this act, also known as the Ku Klux Klan Act or the Enforcement Act of 1871, was designed and passed by Congress in large part to protect African Americans from Klan violence during Reconstruction, whether that was Klan violence at the hands of local governments or by
Sorry, Laura, I think that your audio cut out. This is Rio. Is Laura's video and audio cut out for everyone else? Yes.
Yes.
For me as well.
Yes, as well.
Yes.
Did we lose her completely?
Yeah, I'm wondering if we lost Laura altogether, if she lost her connection.
I'm wondering if she is potentially trying to reboot back in. So
Yeah.
Amber says she's learning a lot already, and I agree.
Funny conspiracy,
too.
it could be.
Oh,
it's
there
the-
she is.
There she is.
Yes.
Hi guys, sorry about that. Horrible time for my internet to drop out. Are you able to hear me okay?
Yes, we can hear you. We can't see you, though. I'm not sure if
Okay,
that's
great. I will
intentional or
address
not.
that in a second. I
Yeah,
just turned
take
that
your
off so
time.
my computer thinks
Laura,
about
while you're
letting me back in.
while you're getting back in, we've got a comment in the chat from Amber McCullough Williams saying, "I'm learning a lot already." So I think a lot of us are.
That's awesome. That's great to hear. Yeah, qualified immunity is not, it really came to, okay, hold on. I think
Take your time.
my camera will let me exist again.
We
Okay.
can see you.
Let me reshare my screen. I appreciate you all. All right, we're back.
Cool.
Qualified immunity really wasn't in standard I feel like it wasn't really on like social media, or no one was really talking about it really until the murder of George Floyd in 2020. I say no one. Obviously, impacted communities have been talking about qualified immunity as long as it's been impacting them. But I feel like it was really thrust into the public consciousness in 2020, and since has sort of waned out. And so I also learned a lot when I first learned about qualified immunity, and I feel really grateful to be here to talk to you guys about it. Okay, I think where I was what I was saying, that the Enforcement Act of 1871 was created to protect African Americans from Klan violence during Reconstruction. And so what it did was it created a legal avenue for people who had been deprived of their constitutional right by someone acting under the law, so that they could seek relief in a court. So that part of the legislation is codified in a federal statute. It's called Section 1983. The only reason you need to know that is because it's the most widely used civil rights enforcement statute. Almost every constitutional and civil rights case that we see is a Section 1983 case, because it's one of the only ways that individuals can sue a government official in civil court over civil rights violations. So top line of that, Section 1983 is the cause of action that lets you sue a government official when they violate your rights. In 1982, the Supreme Court introduced qualified immunity as we know it today, and they put forth the clearly established standard that we touched on just a little bit ago. So when they refocused this definition of qualified immunity, it was on the objective legality of a public official's actions. And they held that an official could have qualified immunity as long as their conduct didn't violate a clearly established statutory or constitutional right of which a reasonable person would have known. And over time, the way that's been interpreted is, unless there is an identical case in identical circumstances, you cannot say that the right was clearly established and the individual is able to receive qualified immunity. This is a legal doctrine that's been criticized by legal scholars across the political spectrum, as well as a host of impacted individuals, community organizations, and advocacy groups. It's something that Congress never voted for. It's entirely court created and court expanded. So like I said, I want to talk a little bit about some cases so we can get more examples of what this actually looks like. Before I get into this, some of these case descriptions involve sort of graphic interactions between public officials and individuals. So if that's something you want to mute me for on your personal computer or briefly leave the meeting for, completely understand, and feel free to do that at any time. And I'm sure Rio and Jennifer will let you back in when you feel as though it's the time for that. So the first case that I'd like to talk about is the City and County of San Francisco versus Sheehan. This was originally in the Ninth Circuit in California, and it did make its way up to the Supreme Court. So today I'll be talking about the Supreme Court analysis of it, since that was the most recent analysis, and as it's the highest court in the land, the final analysis. So the story in this case is that officers were called to Teresa Sheehan's group home to take her for a psychiatric evaluation after a social worker reported that she had stopped taking her medication. And when the police officers entered her room, she grabbed a kitchen knife and threatened to kill them, so they retreated. Then, against departmental policy, which instructs police officers in situations like this to respect the subject's comfort zone, to use time and non-threatening communication, and even to call in a hostage negotiator, instead of doing that, which was the policy, the officers chose to re-enter the room and pepper sprayed her. And when she didn't drop the knife, they shot her multiple times. Teresa survived, and she sued for her rights being violated. And her claim was that police officers violated her Fourth Amendment right when, instead of accommodating her disability, they chose to re-enter her room and use excessive force. When the Supreme Court decided on this case, they declined to address whether the officers violated Sheehan's Fourth Amendment right. When courts are addressing whether a qualified immunity violation or whether a constitutional rights violation occurred that warrants qualified immunity, there's two questions that they ask, two prongs. The first prong is, did a constitutional rights violation occur? The second prong is, was that right clearly established? Courts are not required to answer both of those questions. And so a lot of times what you'll see courts do is skip the first question of whether a rights violation occurred. And instead, they'll go straight to, was this right clearly established? And if the answer to was this right clearly established is no, then the officer, the public official, gets qualified immunity. And we never get an answer from a court on whether a right was violated. So that's what happened in this case. The Supreme Court declined to decide whether the officer's use of force violated the Fourth Amendment. And instead, it skips straight to that clearly established prong. And it held that the right was not clearly established. So the officers in this case received qualified immunity. It didn't matter that Sheehan's expert at trial testified that the officers had ignored their own training for interacting with people with mental illnesses or disabilities. Like I said, bringing sufficient resources, respecting the subject's comfort zone, using time and non-threatening communication. Because under the clearly established framework, departing from training and policy isn't the same as violating clearly established law. And so in this way, the court granted immunity without ever confronting whether disability should have shaped that analysis at all. And so now the next person with a disability who has violent force used against them in a situation like this, against departmental policy, they won't have this case to point to use as precedent for their case, no matter what circuit they're in. So this is the Supreme Court. So this applies to everyone across the country. And the court had the opportunity to establish this as a Fourth Amendment rights violation, but they didn't. And like I said, that's not uncommon. And we'll see in a few more cases that I talk about that this is often what the court decides to do. So in this case, Corbett versus Vickers, this is an 11th Circuit case. In this case, a deputy sheriff intentionally fired at a non-threatening family dog responding to a call and unintentionally shot and injured a child instead. The claim was that in this decision, the deputy sheriff violated a Fourth and 14th Amendment right of this child, his right to be free from excessive force. And what the court decided was that the deputy sheriff was entitled to qualified immunity because his action of intentionally firing at a dog and unintentionally shooting a 10-year-old, that was not a clearly established right that could be violated. The quote from that case is, "At the time of the incident giving rise to this appeal, there was no clearly established law making it apparent to any reasonable officer in Vickers' shoes that his actions in firing at the dog and accidentally shooting the child would violate a constitutional right." And then they say, "Because we find no violation of a clearly established right, we need not reach the other qualified immunity question of whether a constitutional violation occurred in the first place." So we're seeing the same thing again here. There's no decision on whether a constitutional violation occurred. Instead, they're just skipping to granting qualified immunity. So similarly, we're not building any precedent for if this rights violation were to occur next time. The last case in this group that I'm going to talk about is Safford Unified School District versus Reading. This is another case that made it up to the Supreme Court. And in this story, Savannah Redding, she was an 8th grader at Safford Middle School, and she was strip searched by school officials based on a tip from another student that she might have ibuprofen on her, which was a violation of the school policy. Ms. Redding filed suit against the school district and the school officials responsible for the search, saying that her Fourth Amendment right to be free of unreasonable search and seizure was violated. And when the Supreme Court took up this case, they agreed. They said in this case, yes, Savannah's Fourth Amendment rights were violated. This is a constitutional rights violation. However, they also held that the school administrators who had performed that strip search could not be held personally liable because the clearly established law did not show that the search violated the Fourth Amendment at that time. So this is an example where we're seeing they are saying, okay, this was a rights violation, but the officials are still receiving qualified immunity because the rights violation wasn't clearly established at the time. The right wasn't clearly established at the time. 3 different cases, 2 of them showing where they skipped the first question of whether a rights violation occurred, and the third where they do address that a rights violation occurred. But in all 3, all public officials get qualified immunity. So now that we're here, we'll hold out on sharing. You can feel free to put it in the chat if you like, so we can see what our community is feeling in response to these. But I just want you to think to yourself, like, what do you feel when you're hearing these stories, and what's standing out to you? And if there's anything that surprises you, what is it? Because it can be very surprising how things that seem so clearly wrong and like there should be a remedy for and justice for, that there isn't. So I'll give a second for us to pop into the chat what we're feeling, thinking, or if you just want to feel and think it to yourself, it's also completely fine. Yeah, I also feel big mad, Amber. Yeah, rage and numb is definitely possible. And Rio, to your point, one of the reasons that I was super excited to collaborate with you on this presentation is because, like you said, the system is rigged against marginalized people. And we're specifically concerned about how qualified immunity can be used to deny individuals with IDD justice when their rights are abused by public officials, because already vulnerable communities are especially at risk with QI. Yeah, definitely. I don't know if this is what I would call good news, but it's not entirely hopeless in Illinois that this is the system that we have to be stuck with, because the Illinois Accountability Coalition, which is comprised of impacted individuals, like-minded nonprofit organizations, and community members, is working together to support Senate Bill 3699, which is the Illinois Accountability Act. And so this proposed legislation would create qualified immunity reform in Illinois that would allow for lawsuits to proceed against public officials who violate rights without qualified immunity being allowed as a defense. So under the legislation, Senate Bill 3699, what that proposed legislation would do is that it would create a state cause of action for violations of rights under the Illinois Constitution. And in that state cause of action, it would prohibit the use of qualified immunity as a defense. Bob, do you want to pop your question in the chat real quick?
I can say exactly like it, I think, which is, it's, this is nothing, this is not unusual, because as of now, disability rights are being violated everywhere. So this is no different.
Yeah, it is no different. I agree.
That's all.
So the difference between why, so let me back up. So like I talked about, qualified immunity is a federal judicial protection. And so the state of Illinois can't end qualified immunity nationwide. But the state of Illinois can create a channel to sue at the state level that says you can't use qualified immunity as a defense. So it's sort of a workaround, but it will work to provide justice in the state of Illinois for state and local officials who violate constitutional rights. So this bill would require those public bodies to pay damages and attorney's fees to prevailing plaintiffs in these suits. The reason that it's written like that is because when an individual has their rights violated, and if that's confirmed by a court, they're entitled to damages. And public bodies are usually able to cover those damages in a way that an individual cannot. As well as when the public body is held accountable, it encourages systemic reform and better hiring, training, and firing practices, which is ultimately what the goal is of this systems-based accountability reform, is for the systems to be better. The reason for the attorney's fees is to make sure that attorneys are incentivized to take on these cases. It's currently quite hard to find an attorney to represent you if you have a Section 1983 claim to bring, because it's very hard currently to win on a claim like that. This bill would also eliminate statutory immunities and sovereign immunities. So basically that means any other bill in Illinois, any other statute that says that you can have this immunity as a public official, this would supersede that. And then it allows claims to continue after the death of a party. It mandates public record keeping, and it makes it easier to terminate officials who are found to have violated a victim's right. So that's really helpful because oftentimes it can be hard to fire police officers or fire state-operated developmental center employees because of other protections that hold their employment in place. But we've written the bill as such so that if a right is found to have been violated, it's pro se evidence to terminate that public official if the agency wishes to. So now that I've talked a little bit about the bill, I want to go back to one more case so I can talk about what happened in this case and then compare how, if North Carolina had had a bill like the one we're working on in Illinois at the time, how things would have been different. So again, I'm trigger warning this story for their abuse against a school-age child with developmental disabilities. I'm going to give a second for anyone who wants to mute me or hop out. I'll be talking about it for just a minute and you can hop back in or unmute me. So in this case, RA versus Johnson, a autistic first grader with limited communication was repeatedly abused by his special education teacher. His teacher put him in a trash can and told him that if he was going to act like trash, behave like trash, then he would be treated like trash. She denied him a desk and had him stand all day. She even burnt him with spilled hot grease from her lunch. Another teacher witnessed this abuse and reported it up the chain to 4 school administrators, principal, 2 superintendents, and an exceptional children director. But none of those school administrators reported it to the authorities or investigated, and that teacher kept the child in her class for a second year. The abuse only stopped after an outside therapist reported it to the sheriff, and the child's mother sued. When the Fourth Circuit took up the case, they dismissed, well, before the Fourth Circuit took up the case, the Section 1983 claims were dismissed in a lower court. When it got to the Fourth Circuit held that the administrators were entitled to immunity because the act of deciding what to do about a report of abuse counts as a judgment call. And whether you have to, when you have cause to suspect abuse, that's a judgment call. And so that kind of immunity is granted for individuals who are doing judgment calls in the scope of their official duties. You can't say that it was that any reasonable person would have known in their shoes that it was a violation of a right to not report that abuse, is what the court held. And they said, that kind of immunity can only be overcome by showing that the officials acted with malice, which the mother argued that their failure to act was itself malicious. But the court said that being recklessly indifferent is not the same as intending harm, and the officials were granted immunity. If the bill, like the one we're working on in Illinois, had been in place at the time, the Section 1983 claims never would have been dismissed in the lower court. Those were the constitutional rights violations claim. And then when we got to the Fourth Circuit, these other immunities, this public official immunity that was granted to these North Carolina officials, they wouldn't have been able to receive that either, because that wouldn't have been a defense that they could use under the cause of action. And so if a bill like the one we're working on in Illinois had existed in North Carolina when this case was in the court system, it's likely that the child who was the recipient of this abuse and these rights violations would have had a pathway to hold the special education teacher and the school administrators accountable. And the reason I say that is because in the closing opinion, one of the judges of that case, she was lamenting the fact that this was the decision that the court had to hand down. She acknowledged that the facts were egregious, that the behavior was egregious, but she ultimately said that North Carolina has not yet chosen to reconsider its doctrine of public official immunity. Unless and until that day comes, we can only apply the immunity as the law requires. And what she's saying here is she's a judge, not a legislator. So she has to apply the law as it exists right now. This is her saying that she feels like her hands are tied, and she's saying that she can't make any other decision as a judge until there is a pathway to do so. And that's why it's really important to create that pathway to do so. And that's why we're working on that in Illinois. And so ways that you can get involved if this is something that you are interested in getting involved with. We have a letter going to lawmakers that's saying that you support Senate Bill 3699 and accountability. You can sign on to that. There'll be a QR code at the end of this presentation. You can also contact your lawmakers directly over the phone or with a meeting request to ask them to support accountability reform. You can share coalition resources. That's the Illinois Accountability Coalition. You can share those coalition resources with your networks or community to learn more. We're also always happy to co-host a discussion or listening session with your community, whether that's a church group, mom's group, a different civic organization. I'd be very happy to collaborate with you to lead a presentation either like this or a different one that we come up with together to educate about qualified immunity and its importance of getting involved in reforming it. And then when we're in the legislative session, as I know many of you are familiar with from your work in Springfield with the Going Home Coalition, we would love to have anyone who's interested participate in Capitol Days, submit witness slips, or testify in support of the legislation. That's the end of my presentation. I would love now to answer any questions that you may have. Like Rio said, this recording will be sent out, and I will also be sharing some materials with Rio from the Illinois Accountability Coalition to send out as well. That, again, have that summary of what the bill's doing. We can send out the bill text. We can send out a coalition letter and all of that stuff. But happy for any questions, and thank you guys so much for your time. Yes, Rio?
Yeah, sure. Thank you so much. I think this is a really difficult and important conversation to be having. So before we go into questions, I just wanted to give us like 30 seconds to like adjust to the like very intense court cases that we just heard about. Just like if you're someone who feels things deeply in your body, shake things out. Find some grounding because obviously like this is very important work, but it also like many of us in this room have experienced discrimination at the hands of staff, at the hands of educators. So I just wanted to give us that space. And then I do have a question. So let's just take like one big deep breath together. So I would love, before we address everyone's questions, if you could just talk about the current bill status, kind of obviously we are not in session right now, we're going into veto session. So like what is the coalition's game plan? Because lots of us are already like looking to the future. We have legislation that may not pass during this session, during the veto session. So we're kind of prepared for that with other pieces of legislation. And then can you also just talk about the sponsors you have now? And while you're having the discussion about the sponsors, just give the context that you gave to me about kind of like the current moment that we're in and the support that you were able to find and like the conversations that you were having with legislators.
Yeah, absolutely. I would be happy to share that background. Okay, the first question was it the status of the bill? Was that sorry, I'm trying to remember the
status, okay. Game plan, legislative support.
Status, game plan, support. Yep. Okay. Status of the bill. Currently, the bill, it did not pass in the last legislative session, which is what we expected. Because when we were talking with legislators about sponsoring this bill, what we heard from a lot of them, especially legislators in the Black Caucus, which historically in Springfield is the caucus that qualified immunity reform legislation has originated from. We heard from them, many of them, that because it was an election year, they were hesitant to sponsor a bill to end qualified immunity because of the controversy, I guess you could say, that had surrounded it in the past. Not that qualified immunity is a controversial topic. It's not necessarily partisan. It's not necessarily controversial, but it can be perceived that way. And what we heard from legislators was that it was too risky of a time with their upcoming elections to take on that sort of to cover this bill and take on that perception of controversy or polarization. That being said, in those meetings with legislators, they encouraged us to go get as many community organizations and individuals as we could signed on in support of the legislation, and really just making our coalition incredibly robust to come back to meet with them in the interim to give them an update on the support that we were amassing across the state. And our game plan for that is that we have been doing public education presentations like this. We were in Springfield over the weekend and we had a big community event. It was a brake light block party. We changed people's brake lights for free, and we had bounce houses for kids. And I don't know if any of you guys live in Springfield, but I know we were out knocking doors and hanging door hangers. So if any of you got those or came, that was the Illinois Accountability Coalition. But basically, we're just doing a massive push in the summer right now to get as much support as possible. And then the plan going back is to get more sponsors signed on. Our sponsor for Senate Bill 3699 last session was Senator Guzman, but we have several good leads on legislators to connect with who could sign on as a co-sponsor. And in our Capitol Day in April, we were able to get meetings scheduled to discuss signing on. Did I miss anything that was in your question, Rio?
No,
Great.
that was perfect. Thank you.
Mm-hmm.
I think Bradley was first, and then Bob.
Hello. I love what you guys are doing. I'm actually a Justice Administration, criminal justice minor in college.
Mm-hmm.
I would love to stay involved in all of this.
Thank you for sharing. I'm really glad that you're here and you're interested in staying involved. We'd love to have you on as a coalition member.
The thing that I was going to say was, if you could send that letter that your coalition has, that I would glad to send it to our legislators.
Rio, are you able, or Bob, are you able to just repeat that one? Sorry, my volume was cutting out on that.
Okay. You said that you have a letter that your coalition is sending to legislators. So I was saying that if you could send the letter that your coalition is sending out, then I will be more than happy to send it to my legislators.
Got it. Thank you. I got it that time. Yeah, we would love to have you sign on to the letter. I realize now that I only put a QR code and I did not put a link, but when I follow up with Rio, I will make sure to include the link to sign on, as well as a Word document of what the text is, so that you can take a look at that and add your name onto it to support it.
Thank you. That's basically all I wanted to ask you. I mean, I want to ask you more, but that's basically it.
Well, thank you.
I think Amber was first and then Curtis, or Curtis, were you first? I'm sorry, guys. I was listening too hard.
This is Amber. I have a question, Laura.
Mm-hmm.
And I want to check for my understanding, but I'm going to use some things that are less triggering than the actual cases. So let's talk about farting in public. Let's just pretend that that's against the law.
Okay.
So or maybe I shouldn't have said if it's against the law, but I'm feeling like we have some clear, to me, it seems like common sense civil rights were not honored, right?
Right.
But there was no clearly established law. So let's talk about like farts. So, or I'm just trying to make it more neutral by saying
Yeah.
that, just to be kind of silly, but also make it easier to talk about. So if there was no clearly established law, can anybody help me phrase my question better? Does anybody see what I'm
Can
saying?
I say
Yes.
back to you what I think you're trying to get at, and then you can let me know if
Yes.
I'm understanding?
Yeah.
So let's say that most people would agree that like it is against the law to fart, or that it is a constitutional rights violation if you fart on someone.
Yeah, there you
But
go.
then if a school administrator was to fart on someone and it went to court, is your question, like how is it possible that if we say it's a constitutional rights violation to fart on someone and then someone does that, how can it come out of the court saying that wasn't a constitutional rights violation?
Yeah, essentially. That's what's hard for me to understand. And also, I was kind of thinking about it because I'm a parent of 3 children with disabilities, and I was thinking about just as I parent, sometimes I say to them, I don't need to tell you, like, don't hit in the car. The rule is don't hit. Like, I don't need to come
Right.
up with every little iteration of the rule,
Right.
right? So is it like an
Yes.
iteration of the rule that they're not
Yes.
um
That
hearing
actually is
specifically?
such an excellent way to put it, which yes, that's one of the insidious things about qualified immunity, is that it almost incentivizes public officials to break the law or to violate someone's rights in like innovative ways that haven't happened before. Because if you can do it in a way that hasn't happened before, then
Mhm.
there's no, prior case, like you're saying. And it's exactly like you're saying. Like you shouldn't have to say this isn't right and this isn't right and this isn't right, like to your children. But in the
But the
court,
principle is we don't do that.
right, exactly. But the specificity required to overcome the qualified immunity defense is so high under that clearly established standard that generally and most often you do need to have that incredibly specific identical matchup in order to deny qualified immunity. I like the way you put that.
That's a really
And you're right,
high
it feels
bar.
wrong.
Yeah, yeah.
And I think too, one of the insidious things is because the court can skip that first question of whether a rights violation occurred, it's not required for that precedent to build up. And so it's sort of like our rights that you can't violate are frozen in 1982 when qualified immunity as we know it was established, because it's so rare that the court is deciding whether a rights violation occurred to add to that body of precedent that says what is unconstitutional.
Okay. I really appreciate you clarifying that. That helps a lot.
Yeah.
Okay, we've got Curtis and then we've got Jennifer, and then unfortunately we will have to stop questions after that. I wish we had extra time for this. This is a really engaging conversation. But please email Laura if you have any questions.
Please email Laura. Yes, I would love to. And I'm happy to get on the phone with anyone as well who wants to talk more about it. Curtis, did you want to go ahead with your question? Then we'll end with Jennifer.
Yes, I want some questions talking about the immunity and
Mhm.
how these cases have been violated. And we'd like to see Illinois finally sign legislation to protect the Fourth Amendment rights and Fifth Amendment rights. I mean, Fourth Amendment rights. I don't know why I'm saying Fifth, but anyway, because those rights are being violated when people are being shot by police, or those who are being, like I said, students being put in garbage all day, stand all day, which is unhealthy and inhumane treatment by the school teacher. So will these bills and laws protect those against inhumane child abuse treatments that the students get in Illinois, and those who get shot by police. Hope these rights are protected.
Yeah, I hope so too. And thank you for that was a really excellent recap of why it's important to support qualified immunity reform in Illinois. And it's a great intersectional point that you bring up too with yes, this is an issue that specifically relates to the IDD community in terms of often school administrators and social workers, other public officials, but there's also that intersectionality aspect of what about individuals of color with disabilities who are at heightened risk of, violence from police or from social workers, whether, so I appreciate you bringing attention to that as well. Jennifer, do you want to close us off?
Yeah, I don't want to get in the weeds just because there's so many questions. I'm very confused about. It sounded like you were saying that the teachers, it was almost like they shouldn't have known to report this, where Georgia is also a mandated reporting state. So it doesn't even matter if it's on the books. Is that what I'm hearing? Even if it's on the books, a requirement. And I mean, maybe they weren't at that time, but if it's on the books that, this is something that you can't do unless it's been brought up in a qualified immunity case, it still doesn't matter. Am I understanding right?
That's a good question. The one thing I'll flag is this case was in North Carolina, so I'm not sure about Georgia. The initials for the minor are GA, just for clarity. It's when it's minors, they do initials. In North Carolina, I'm not sure if North Carolina is a mandatory reporting state, and I would have to look into specifically what the intersections are between mandatory reporting statutes and qualified immunity. My guess, based on the way that, and again, this is not, I'm going to look into this for you, but my guess here would be that because in the court's analysis, they said that there was a decision making, what's the exact wording that the court used? It's like discretion, decisions that involve their judgment. So decisions that involve judgment, what the court was saying was that the public officials deciding what to do about the report of the abuse counts as a judgment call, because figuring out whether there was cause to suspect abuse in the first place was the judgment call. And so what the court was saying was that the administrators, it wasn't required for them to report abuse if they were unsure whether the abuse was happening in the first place, if that makes sense. So that was the basis of what that immunity was granted on. I imagine if it was like a mandatory reporting, again, I'm not that familiar with those statutes, but there may also be that sort of judgment call aspect to that may allow for that immunity to still be granted. But that's a really great question, and I'm going to look into it because I'd like to know the answer as well.
Well, thank you. I wish I didn't have to learn all of the things I learned today, and I appreciate you being willing to share the hard things. I want t-shirts. I don't know. I want videos that I can pass along to people, and so that, it's so many people see, just like so many of our issues, this much of it, and they don't understand the impact. So whatever we can do to help,
absolutely
pass that along. So thank you again. Rio, I don't know. I think our next step might be me sharing some of our upcoming things.
You're up next.
Okay.
Let me end my screen share.
Thanks.
Well, thank you everyone for hanging with such a hard topic. Like Amber had shared, we can be prepared, but it's still hard. So if you have any thoughts afterwards, feel free to message Laura, Rio, or I, because we do want you to not have to just sit there holding that, feeling uncomfortable. And thank you for all the great questions. moving ahead as far as organizing is concerned, we are going to plan for organizing meeting that's going to be happening on Thursday, which we'll have the specific details for that on the next slide. But for the Going Home Coalition organizing meeting, it's going to be next Thursday at 10 a.m. We're going to be planning for the Disability Pride Parade, talking about the Liggett consent decree hearing. You're going to get updated on the progress on the video project that's happening. And we'll have a discussion about the 1 million care conversations that is being sponsored by Caring Across Generations. So I hope you all are able to join us for that. So that one will be on July 23rd at 10 a.m. And then the next Rev Up Illinois meeting, which is promoting the disability vote in Illinois, is going to happen on Thursday, August 6th at 6 p.m. And then our other August sessions will have our next Going Home Coalition education session. We're going to continue on the same theme. We're going to talk about pretrial justice on August 19th at 6 p.m. And then we'll have our August Going Home Coalition organizing session on August 27th at 10 a.m. And we're going to get those in the chat for you so that you can get registered. We've got some registration links I'll pop in right now. And then the events that we've got coming up are the Disability Pride Parade on July 25th. That's a Saturday from 10 to 2 p.m. We're really excited. Rio and I will both be there, and a number of people in this room are going to be in there as well. So definitely join us for that. If you want to know a little bit more about how to get involved, let us know. We've got the Colbert Williams consent decree hearing on July 22nd at 9:30 a.m. We would love to get as many people as we can in the room just to show our presence and to make it apparent that we are listening, that we care. These things matter to us. And the same thing for the Liggett consent decree hearing on July 30th at 1:30 p.m. So, and both of those, Rio has talked about those in some of our past meetings. So if this is brand new to you, feel free to email Rio or I. We can talk to you about it directly, and we can definitely get you a link to some of the presentations where we've gone into it, and well, Rio's gone into it in a lot more detail so that you can get more information on that. And thank you all for coming. I've got the links and the registration in the chat. If you want to grab those, we will be sending out the recording of this, and those links will be in there as well. And then if anybody wants to reach us in the meantime, I've just dropped our emails as well. So thanks everyone for joining.
Thank you so much, Laura. And thanks everyone for a really engaging conversation.
Thank you.
Thank you.
Thank you.
Bye, guys.
Bye.
Good night.
Bye, Rio.
Bye, Karthik.